Good morning again, Your Honors. Mateo Caballero, I may please the court. Mateo Caballero for plaintiff appellant Stephen A. Heyer, who again is the father of Stephen K. Heyer, and he's here with us in court. Stephen K. Heyer was a 32-year-old disabled veteran with a history of mental illness who was experiencing an acute mental health crisis and had locked himself in his bedroom up in the North Shore of Oahu to avoid being taken in custody for a medical examination by the Honolulu Police Department. The Honolulu Police Department SWAT unit responded, cleared the house entirely, and set up a perimeter around it. After that, just over 2 hours after the SWAT team was fully in place, Heyer was shot with 9 rounds of chemical munitions, attacked by a police dog, and eventually shot dead.
Let me ask you this. These are really sad facts, and we've all read those. Let me ask you, when is it reasonable for a district judge to throw out an entire report? You had 3 experts, all those reports got thrown out. When can the district court do what it did properly?
Well, I think the district court has to actually review the reports, look at the conclusions. If some of them, and we will admit that, for example, some of perhaps the conclusions by Dr. Daniels could be stricken out, but to just wholesale strike the entire report, we would say is clear abuse here.
So from your perspective, the judge could have said, okay, report number 1, I don't agree with you. This part's out, that part's out, that part's out, the rest stays in. Is that what was required here?
Absolutely, and you know, in cases that I've brought to trial, that's what happens. Very often there's a motion in limine, and then the court goes through the reports, and they strike portions of the report that are, you know, redacted, and what ends up going to the jury is a heavily redacted version of the report. But wholesale, you know, getting rid of the entire report, you know, particularly in a situation like here where there is no claim that, you know, their expertise is that they're not experts in their field, or that some of their opinions are...
What are the opinions in Dr. Daniels' report that you think could be stricken? When he talks about what all the Honolulu Police Department officers knew, that also seemed like beyond his knowledge? Or?
Absolutely. Things beyond his expertise, things beyond what he actually knew. But ultimately, at least for purposes of...
What about whether the tactics the police used, is that something that Dr. Daniels should have been opining about?
I mean...
Forensic
I would say that's a closer question, and of course we do have a police expert here, Mr. Defoe. But for summary judgment purposes and for purposes of this appeal, we would submit that the important thing is that he was absolutely qualified to opine as to the disability that Heyer had. His mental state. Yeah, his mental condition. And he had reviewed his medical records, he had reviewed what happened that day, and he was entitled to make an opinion as to...
What's important about the experts is their opinions.
Excuse me?
What's critical about experts, like the ones we have here, are their ultimate opinions.
Yes, absolutely.
Based on these facts, Mr. So-and-so, Dr. So-and-so, what is your opinion to a reasonable certainty?
Absolutely. That's what ultimately was important in the case, was their opinions, and here the opinion that he was disabled is important to his ADA claims, or is relevant to the ADA claims.
Let me ask you this. So, even if we were to agree that the district court erred in wholesale striking all the 3 expert reports, you have to show some prejudice to get a reversal just based on that.
Got it.
So, how would the reports have played out in this?
Well, we would submit first, again, that, for example, Dr. Daniels' report showing that he was disabled is relevant to the ADA claim and whether he was reasonably accommodated.
How about at the time of the incident?
Excuse me?
How about at the time of the incident when he was shot?
Well, then you have Dr. Sperry's report, and he opined based, he's a pathologist, and he opined that based on the wounds to the body and reading the report, that he was shot on his right arm and on the chest. One of the bullets went through his arm, through the armpit, into his body, and that essentially, and all officers reported this, that he had his arrow on the right hand side, the bow on the left hand arm, and if he was getting ready to shoot, it's unclear how, if he was presented this side of the body, he was in any shooting position whatsoever. And that opinion, he's qualified to give based on the review of the report.
So you concede that Mr. Heyer was holding the bow and the arrow?
Absolutely.
When he was shot?
Yeah.
Your only dispute is that it wasn't in a shooting position?
Well, the dispute is that there was no immediate threat of bodily injury to the officers at that time. He was essentially defending himself against the dog that was attacking him. He was hitting the dog with the bow, striking it with the arrow, and in fact he suffered 12 wounds to his left arm, and there was no time, there was no threat to the officers.
No, the officers say just the opposite.
Well, not all of them.
Right, but is it, who was it fired? Not Silva, but Torres fired the shots?
Yes, but you have...
Torres, I thought Torres, initially he didn't say anything, but he later said that, didn't he later say that he had the gun, the bow and the arrow in position?
Yes, you have two... Yes, you have two officers that said that after the fact. But Torres, as Your Honor just mentioned, initially when he was interviewed about the use of force, he doesn't say anything.
Correct.
And then you have two other officers in that room. One who was, on the side looking for other threats. And then you have the dog handler. And neither one in the reports they mentioned that Heyer was pointing the bow and arrow at the officers. So under those circumstances, we would submit you cannot have self-serving, statements by the police that, have to be taken as true. But instead, that the question of whether Heyer posed an imminent threat to the officers is one for the jury to decide.
How should we think about the law that says that the officers don't have to wait till the gun is pointed at them before they can take action?
Sure.
How should we think about that? Were they required to wait until Mr. Heyer actually pointed the bow and arrow at them?
So there are, I believe there are 4 cases here that inform that question. We have a state of Lopez v. Gelhaus. We have one that was cited by the district court, Cruz v. City of Anaheim. You have Colonel and Ridgecrest Police and Harris v. Roderick. And the way I read all of these opinions is that the fact that you're just armed is not sufficient. So if you're just armed, officers cannot just go ahead and shoot you. There has to be some sort of, harrowing movement. There has to be some sort of indication of threat.
Equivalent of a brandishment. Here we have a bow and arrow. So it's a little different, but could a reasonable officer, in this case Torres, if he is reasonable, have looked at the attempt to, if you will, fire, brandish, showing I've got this arrow, I got this bow. It could have interpreted in the same way as if he had a handgun. Hadn't pointed it yet, but he had it out. Is that the same or somewhat similar?
Well, we dispute that he was getting ready to shoot the arrow at all.
Understand.
What we contend here is that he was just defending himself against the dog, and there is sufficient evidence in the record to support that. And if that's the case, if all he was doing was defending himself against his dog, and he was not in fact threatening the officers, not making any harrowing movements or anything like that, then there is a claim for excessive use of force under the precedent that I just cited.
Is there any suggestion in the record that they were also concerned about the dog's safety?
Yes, there is in fact. The mayor in charge of the entire operation mentioned in his report that he was shot to protect the lives of the officers and the dog. And not only that, but also one of the officers who was just outside, in fact, I believe it's the officer who was getting ready the munitions to continue firing chemical munitions into the room, he heard, "Stop killing my dog," and then shortly after the shots. So we believe there is, in fact, evidence that all he was doing was defending himself against the dog.
So let me ask you, there's a couple of, your time is beginning to run out, but there are a couple of other bases for your claims. One is the firing of the canisters and releasing the dog.
Absolutely.
So why was releasing the dog excessive force?
Well, what we contend is that between the shooting of the canisters, again, 9 munitions into a small room, and the releasing of the dogs, all that had happened was, nothing had materially changed at that point. There are some statements, and we submit that they're hearsay, from perimeter officers who said he had brandished the weapons or brandished the bow and arrow in the meantime. But at the time he was actually, the dog was released, he wasn't armed, or at least there is no statements on the record that he was armed at that point. And we don't know why he was coming out. Perhaps he was, ready to give up, or he needed air. I mean, there was a lot of gas inside his room. So what we submit is that at that point there was no imminent threat to the officers, and therefore there was no reasonable, it wasn't reasonable, objectively reasonable, to release the dog to attack higher.
What is the strongest case you would have to show that the use of the munitions and the dog was unconstitutional?
Meaning legally, what cases?
In other words, was it excessive force?
Sure. I believe the most analogous cases, there are a couple of ways of viewing this, but one of the analogous cases is Bryan v. McPherson, which says that if you're going to use intermediate use of force, you need more than a minimal government interest at stake. And here we would submit that looking at all the Graham factors, most of which, or pretty much all of which, particularly in the use of the munitions, weigh in favor of not using intermediate force, that the officers should have known that was excessive, particularly when it was 9 chemical munitions shot into this small room. And the other case that is relevant there is both Headwaters Forest Defense v. County of Humboldt, both cases which essentially say the use of chemical munitions is more than just the use of minimal force. It's actually significant use of force. But the other cases that I would like to point out to the court is the Oral v. Rutherford, which, and I'll quote it, every police officer should know that it is objectively unreasonable to shoot, even with lead shot wrapped in a cloth case, an unarmed man who has committed no serious offense, is mentally or emotionally disturbed, has been given no warning of the imminent use of such significant degree of force, poses no risk of flight, and presents no objectively reasonable threat to the safety of the officers or other individuals.
Do you want to say?
Yes, I'll say 3 minutes again.
Can I ask one last question?
Yes, sure.
What about reasonable mistake of fact? How should we consider that with regard to the shooting, perhaps?
Well, Your Honor, we would submit that there is no reasonable mistake of fact, and that the officers, in fact, Torres came up after the fact with explanation, after having shot Mr. Heyer, with explanation that he was getting ready to shoot the bow and arrow. We would submit that just didn't happen, and it should be a determination by the jury if in fact that happened or not. And the cases there that we would, again, point to the court to is Cruz and Galehouse, where again the question was ultimately that those types of issues about whether there was a harrowing movement, whether the person was in fact getting ready to shoot, let's say, a firearm, should go to the jury. I'll reserve the rest of my time.
Very well. Okay. A. Wong, is that correct?
Yes, Your Honor.
Please proceed.
Good morning, Your Honors. May it please the Court. I am William Wong, Deputy Corporation Counsel for the City and County of Honolulu, representing the City and County of Honolulu, as well as the individual officers, Malo Torres, Wayne Silva, and Paul Nobriga. I think before I get into my recital, I just wanted to clarify something that I think is misunderstood about the initial statements given by the officers. There was no discrepancy, or there was not any significant omission. Those initial questions, and you can see this in ER 483, when they're read by Officer Nobriga to Officer Torres, he's not interviewing them. There are 4 standard questions, and those are the only ones that are allowed to ask. He even says in the thing, he read the questions verbatim. None of those questions required to respond why he did what he did, or those. The 4 questions are, from where and in what direction did you fire the rounds? In what direction did the suspect fire the rounds? If you know of anyone injured, what is his or her location? Are there any suspects outstanding? And does any evidence need to be recovered or protected? Those are the 5 questions they're asked. So it's inaccurate to say he gave an initial statement where he failed to represent accurately what he did in the room.
Are these questions that are internally generated by the police department, or these were from the plaintiffs?
No, these are standard questions that are asked immediately upon a critical incident.
By the department itself?
By the department itself. So, Your Honors, we are asking this court to affirm the trial court's granting of both the city and county of Honolulu and the individual officers, the individual officer defendants' respective motions for summary judgment.
Let me ask you this, counsel, as we did with your opposing counsel. Judge Gilmore's a very respected judge, a lot of experience. In this case, she had three important expert witnesses, at least important from the perspective of the plaintiffs. She struck the entirety of each of the reports. That's a little unusual. Would you agree on behalf of your client that perhaps Judge Gilmore could have been a little less heavy on the pen and maybe had some portions of it qualify as appropriately admitted?
Do I agree it's possible to go through that analysis? Yes. Do I think it was necessary in this case? No, I do not.
Okay. You don't think that admitting, well, my colleagues have referred to portions of the record that could have come in your view, if those portions, you know what I'm talking about, which portions, would you agree that the plaintiff would have been prejudiced by their not coming in?
No, Your Honor. I think even had, and the court even addresses this in the order, even if the court were to have allowed the opinions of the doctors in, that wouldn't have changed the outcome or would have...
Would it help to create a tribal issue of fact?
I do not, Your Honor.
Why not?
Because as the court said, whether... I'm sorry,
No.
As the court said, the analysis wouldn't have changed. The fact that, well, first of all, Dr. Sperry, it's purely subjective or it's purely speculative, and he refers to this idea of the
Isn't that pretty standard for these cases, for an expert to be opining on what was the position of the decedent at the time of the shooting? It just seems like this kind of report is fairly standard in these kinds of cases.
Yeah, and it's standard when there's evidence, there's some kind of factual basis to put it on. He's not an archery expert. All he's saying is that, you know, and all the evidence, the concrete, unassailable evidence that he's got is the autopsy report. So yes, it is accurate to say that one of the bullets went in through the arm, came out and went into the chest. But from that...
from looking at the autopsy report, why can't he opine, in my opinion, based on review of the autopsy reports and the statements of the officers and whatnot? In my opinion, he was in such and such a position.
Because you still
at the time he was shot.
You still have to have a factual basis, and the only reason...
He's basing it upon, his opinion is based upon the autopsy report.
Right.
What's wrong with that?
Because the autopsy report makes no reference to the position he was in. It just references the...
But can't you follow the path of the bullet? That gives you some sense of the direction that the bullet is traveling.
It gives you... I'm sorry, Your Honor.
Or what position Mr. Hunter was in.
At best, it gives you something to speculate on as what could have been a position. There's nothing to a reasonable degree of scientific certainty. There's nothing more likely than not.
Let me ask you this: was there any argument put forward to the district court that this type of expert opinion is based on junk science?
No, I believe what our argument was and what the court adopted was that it was speculative and that it was not based on, or it had no discernible methodology.
But doesn't the speculative go to weight, not admissibility? That sounds like that's a great cross-examination question. Maybe it's a great closing argument, but just the actual opinion of the path of the bullet and what inferences you can draw from Mr. Heyer's position.
Well, that's just... I'm sorry. That's just it. It's speculative to the point of where it's of no value. All that can be objectively stated is the path of the bullet. To say that he must have been in some kind of formal shooting stance when there's no evidence in the record to suggest that he was in a formal shooting stance is purely speculative, and it offers it's not assistance to the trier of fact to guess at what...
But why isn't there a factual material dispute as to Mr. Heyer's position at the time of the shooting? This is what it all sounds like, right? That there's a factual dispute, like the officer saying he was in a position to actually shoot the bow, an arrow. Why is there a factual dispute?
Because
there was an imminent threat that would have justified the use of lethal force.
Well, two things I will say is there was no factual dispute because the only articulable, non-speculative evidence is that that he'd reached back slightly and was preparing to knock the bow. Second of all, even if that doesn't create a genuine issue of material fact, because as the courts pointed out, they don't have to wait for him to get into a firm stance, or they don't have to wait for him to actually knock the arrow. The fact that he's got a razor-tipped arrow and a compound bow and is even making any motion to load it would have been sufficient in and of itself.
Counsel, are you aware of any case that basically says that doing what the decedent was alleged to have done in this case constitutes the equivalent of brandishment, as if we had a firearm situation?
You know,
What he did with the arrow and the bow, is that the equivalent of brandishing a firearm but not pointing it? So what case would you cite?
I don't think it's the equivalent. I think it goes a step further in that. It's an actual physical move to load the arrow, and unequivocally, the two officers that saw that part said without equivocating that they saw him pulling back the arrow to load the getting ready to fire.
Like, cocking to put a bullet into the chamber, ready to fire?
I think it would be equivalent to cocking and loading the chamber and then pointing the gun at somebody.
So trying to make sense of what happened, all this happened in a very brief period of time, correct?
Yes, Your Honor. Seconds.
Seconds, right? And when the dog went in the room, he tried to defend himself against the dog's attack, correct?
Yes. He was stabbing the dog with...
He was hitting the dog with the bow.
And the arrow.
And stabbing him with the arrow.
Yes, Your Honor.
Correct?
Yes.
And Officer Torres, who comes in, who was supposed to be the high cover. High cover.
Yes, Your Honor.
He was supposed to be backing up, as I understand it, right?
Well, so the first one in would have been Officer Nomura with the ballistic shield.
Yes.
And then kind of off into the right, but still trying to be guarded by the ballistic shield would have been the canine handler, Officer Silva. And then he would have been looking over the high cover position over the shield. Yes.
Okay, so all this is going on. Hire is trying to defend himself against the dog, and somehow or other he's able to fix the bow, what he was using to stab the dog. Get the bow and get the arrow and get the bow in the right position and load it. Is that?
Yes. So what Officer Torres and Officer Nomura said is that he had the bow in his left hand, he had the arrow in his right hand. He would hit, stab, and then it was a simple motion of bringing it back and then knocking the arrow and starting to pull it back.
Now, two officers didn't see anything, right?
Well, I don't know if it's accurate to say they didn't see anything. They weren't looking at that exact time. There was a fourth officer, Officer Otto, who came into the room, and he was looking to the right of where everything was going on because there was a pantry and a bathroom area, and it had unknown if there was anything else in there. So his focus was on there, but occasionally looking back. And Officer Silva was more concentrated on...
Let me ask you this. Why isn't this case a lot like Lopez that counsel referred to? You remember the Lopez case? It was the case with the kid with the toy rifle.
Your Honor, there's multitude of that makes this different.
The Gelhaus versus Lopez. I wrote that, so I know about that one.
Yeah, in this case...
I didn't want to... I'm only concerned about...
Supreme Court denied cert.
The threatening behavior was early and often. It started from the get-go of this case. So police are called because he's threatening his neighbors. He brandishes a knife, taser ineffective.
But they think he's having some mental problems, right?
They think the mental problem is...
I mean, they do call the psychologist at the department and they say, hey, look, this is what happened initially. We came back, here's what he's doing. And the psychologist says, okay, I'll sign an order that you can take him into custody and put him in.
Yes, Your Honor. It's not simply an order that you can take him into custody. There's a finding that goes along with that order, and the finding was that he is an imminent threat to himself and others.
But it was because of his mental. It was because he was acting out. He was saying things like there are dead bodies in the walls.
No, Your Honor. The imminent threat was, or the threatening behavior was, one, he had tried to burglarize the house. He had brandished a weapon. He had pointed the bow at officers. So it's not...
Neighbors had all complained that he was acting out.
Yes, Your Honor. He was also making strange comments and out, but what is...
Let me ask you, you can't, a psychologist, I'd be surprised if a psychologist could just say, well, you take this guy into custody because he's a threat to himself. There has to be a basis for that, and the basis for it was that he was acting out.
Well, I guess it depends on what you mean by acting out, Your Honor.
He was demonstrating mental impairment, signs of having a mental stress situation.
He was displaying signs of a mental, I don't want to call it a mental illness, but a mental health issue, yes. But also, he was displaying signs of dangerous behavior, dangerous to both himself and others. So those are not mutually exclusive. Yes, he was acting out, but what caused them to act the way they did and treat him the way they did is because he was also quite dangerous. It's not a crime to be unusual or delusional. An officer can't take you into custody because you're acting weird. They take you into custody.
Because Washington, D.C. would be vacated.
Yes, really.
The authority that gives them to take you into custody for an involuntary evaluation is that he's an imminent danger to himself and others. So, again, these are not mutually
But that doesn't give a justification to conclude he's an immediate threat, right? Just that he needs to be taken in for a mental health evaluation.
I would disagree, Your Honor. I believe amongst the other circumstances that were present that night, mental health providers' independent determination that he's imminently dangerous to himself and others does constitute...
So you're saying anyone who is subject to being taken into custody for a mental health evaluation then is fair game for lethal force?
No.
Is there automatically an imminent threat?
I'm not saying it's...
That would be a really big stretch, wouldn't it?
No, I'm not saying it's and you can see the form. It's in the record, and it indicates there's a bunch of boxes that they have to fill out, and one of them is imminently dangerous to self and others. That's not the only one. There's also this combative, which also happened to be checked in this case, and there's multiple criteria. But that in and of itself, does that mean they can use force? No, but it does mean that he is now fairly treated independently and can be treated as he's an imminent danger to himself and others. Without more, is that no? But in this case, there was more. He did attack his neighbors. He did have weapons. He did threaten to hurt himself. He did threaten to hurt other officers in the area. So
From the police force's perspective, the deadly force was warranted because the officer truly felt threatened that his life and the life of others there were in danger. Is that right?
That's correct, Your Honor. Deadly force is not used
But
until...
it's disputed, right? Because two of the officers don't see the cocking of the bow and arrow. And the shooting officer, when he was initially interviewed, didn't say that Mr. Heyer was cocking the bow and arrow. So, I mean, it seems like there's at least a material factual dispute as to whether he was cocking the bow and arrow or not, because two officers don't corroborate that.
I would disagree, if I could, Your Honor. I see my time's up, but just to respond to that. I would disagree because, one, the two officers that didn't see it, that's an omission, not an inconsistency. They didn't see it because they weren't looking, because their focus was elsewhere. To say that they didn't see it creates a material fact of whether or not it happened, I don't think is accurate. Sorry, I lost my train of thought. But
Just basically, because they didn't dispute it, the negative precedent isn't that there is a clash. It just they didn't talk about it. So from your perspective, there's only these two who said it happened.
Right, those two are the only one, and they were just honest, right?
Yeah.
Two said they were looking at other things, two said they saw it. And again, I think it mischaracterizes that initial statement, the initial statement that it was inconsistent or somehow that he wasn't forthcoming, because as indicated in the report, these are standardized questions that they're not allowed to veer from. These are standardized questions that the officer in Nubriga said that he read verbatim, and he even wrote the questions out in his report. So it's not as if the officer even had a chance at that early stage to say he was pointing at me. They just want to know the 4 questions that they got and what are the answers to those questions. And for union and SHOPO and collective bargaining agreements, they don't go any further than that. They can't go any further than that.
I just, if Judge Smith would allow it, I
Please.
just wanted to ask you, do you have a response to the release of the dogs and the use of the canisters to your friend's argument that was excessive? under the circumstances.
Yeah, I obviously strenuously disagree with that characterization. I think what is kind of perplexing.
You know, 9 canisters? What
Well, first of
I mean, one wasn't good enough in that small room?
I don't think it was, Your Honor, and there's even testimony directly from Roberta that additional canisters do not provide any additional harm. It may be more uncomfortable. And on top of that, it clearly wasn't excessive when it didn't even work. 9 canisters in that small room, and all he did to respond, and I would again disagree with my friend, is he came out and said, "You guys can't get me," or something to those effect, and pointed the compound bow at the officers again. So 9 was clearly not
How
excessive.
about the gun?
Everything, it was a steady progression, Your Honor. So they had tried a taser. That didn't work. They had tried hours of communication and negotiation.
Well,
That
they didn't
didn't
bring
work.
in the negotiating team.
No, but they did try to negotiate with him and saying,
Come
please,
out.
please come out. We're just trying to resolve this situation peacefully. We don't want anybody get hurt. So there is, and they are trained, they're not the crisis negotiation team, but the SSD team, which has been referred to as a SWAT team.
They were dressed up in their sweat gear, right?
Yes, but they are trained on how to do these kind of negotiations, and they did attempt to do them for hours on end. The initial taser was ineffective. The munitions were ineffective. He was still becoming worse. And I think one fact that's overlooked is that this was a multi-hour event here, and time and resources are limited in that Officer DeBerger talks about that there are 10 officers for that whole district. 5 of them had to be absorbed into this incident. So now from a whole district of the island, there's 5 officers. So it's not simply as if it's just one little narrow, there's a danger to the community. Plus he had a compound bow that was more than capable of going past the perimeter of the officers. It would have taken just a simple trigger pull to fire it into the neighborhood. So I guess that answers your question then. I think my time is well since over.
Thank you.
Very well. Thank you very much. So, Mr. Caballero, we're ready for the pièce de résistance.
Thank you, Your Honor. So just a few quick points. The first one is that I think my friend is conflating imminent threat for purposes of the 14th Amendment and the 4th Amendment. When he was initially determined to be potentially a threat to himself and others, it's just for the purposes of taking him into protective custody, not for the purposes of using force. The second point that I would like to make is that Paul Nobriga, who was in charge of the tactical team, he testified in his deposition that Hire hadn't brandished any weapons in the 3 hours he had been there before the chemical munitions were deployed. He hadn't threatened anyone. He didn't point the one arrow at anyone. And that he did not pose a risk to the community or flight risk. And that's in ER 295-96 and to ER 254. And again, we submit that by the time the dog was released, nothing had materially changed from what he said there. As to the shooting, Torres, the shooter, he didn't mention anything in that initial interview. And the interview is called Officer Involved Shooting Public Safety Statement. And so while I understand that there are specific questions they answer, we would submit that at that point he could have easily just said, he wasn't shooting any rounds at us, but he was getting ready to shoot his bow and arrow at us. He didn't say that.
So what should they have done? You're an officer, you're there, you moved along to the point that all these hours had passed, weren't getting anywhere from the perspective of the police and earlier reports. He's a threat to the community, he's a threat to himself. So what do you do?
Sure. So first, the SWAT team had been in place only 2 hours by the time they shot the 9 munitions. Second, they had options at their disposal. They had the crisis negotiation team. They could have called them. They have a psychologist in there, and our expert Defoe talks about that. They could have tried a throw phone. They could have put a phone next to his the sliding door and allow this person to pick up the phone and try to talk to him. In fact, there are multiple points in the record where Hire was trying to communicate, was screaming, was saying things to the officers, and they couldn't hear him. In fact, Nobriga says that. I was shouting, and he was shouting back. I couldn't hear what he was saying. The other thing he could have done is Hire at one point, and this happened earlier in that incident, after he's tased, he calls 911. He says, "Hey, I was just tased. Please these officers should leave me alone." So they could have potentially gotten his phone number through that through 911, or even through his housemates. The housemates were the ones, the complaining parties here. They could have asked, what is his phone number? Where's his cell phone? Let's try calling him.
Time is up. Let me ask whether either of my colleagues has additional questions.
No, thank you.
All right,
No, thank you so much. I appreciate it.
Appreciate it very much. The case just argued is submitted.